Hi friends, Kim Whaley, Simple Politics. Big issue before the U.S. Supreme Court on affirmative action this term. Just like Roe versus Wade, the plaintiffs, the ones bringing the challenges to the admissions policies of two schools, Harvard and the University of North Carolina, are asking this right-wing court majority to reverse decades of precedent. The precedent here is likewise under the 14th Amendment to the U.S. Constitution. In the Roe versus Wade Dobbs situation, it was the Due Process Clause, which is part of the 14th Amendment. Here, when it comes to affirmative action, it's a different part of the 14th Amendment, Equal Protection Clause. In both cases, we're talking about an amendment to the Constitution that originally was about post-Civil War ensuring that African Americans, formerly enslaved people, can be part of the Union. 13th, 14th, 15th Amendments. 13th Amendment banned slavery. 14th Amendment does the things I mentioned. 15th Amendment gave Black men the right to vote. Fast forward to the 1960s, Congress passed the Voting Rights Act as well as the Civil Rights Act because the states weren't, in the South and primarily, weren't complying with the post-Reconstruction amendments to the Constitution. So the case against Harvard is under the Civil Rights Act because that not just applies to government, but it can apply to private actors. The case against the University of North Carolina is under the 14th Amendment's Equal Protection Clause. As I said, the court has held that universities can take into account, and schools as well, can take into account race in determining the makeup of their admitting class. It can't be a litmus test. It can't be the only consideration. It can't be a reason with no other justification for allowing one student in versus someone else. It can be part of a holistic approach to admissions. The courts affirm that concept twice. So we've got 3 cases out of the Supreme Court that holds that this is a constitutional practice under the 14th Amendment on the rationale that diversity is a good thing for universities, that a diverse university produces a more diverse population, et cetera, et cetera. The argument here being made by the plaintiffs is basically the Constitution, now that we're so far away from remediation for slavery, the Constitution needs to be colorblind. That even though the University of North Carolina uses 40 criteria in a holistic approach, and that there was nothing in the record demonstrating that race was kind of allowed to be the deciding factor for any particular student, that somehow it's unconstitutional to consider race, and that criteria needs to somehow be excised from people's identity when they're applying to schools. It's a real kind of mind-blowing concept to think about race no longer being a mechanism for ensuring equality, but somehow being unconstitutional. It flips the entire dynamic, and it could have implications well beyond affirmative action if, as it looks like, the court reverses decades of precedent on affirmative action. Justice Ketanji Brown Jackson, I think, made a very compelling hypothetical argument that I'm going to share with you that I think crystallizes everything. Now, to be clear, the plaintiffs in these cases were saying, the challengers to these policies were saying, you could, in an essay, for example, talk about your hardship as a minority student from maybe, low-income neighborhood and have race come up as part of your story of hardship, but it would really be about the hardship and not the race. But you couldn't somehow single out race specifically. So she gave a hypothetical where, say, you're a student applying to University of North Carolina and you're arguing, listen, my family's been here for generations. I've had, 5 generations of relatives that have gone to UNC. I want to honor my family's heritage, and that's why I want to be admitted to UNC. That's student number 1. Student number 2 is, my family's been here for generations. They were historically enslaved. I'm the first person in my family that is eligible to go to University of North Carolina. I want to honor my family's heritage by being admitted. In that instance, the answer appeared to be by the lawyer that the student number 2, that would be on their theory unconstitutional, because the whole rationale for admission would be around race. That student number 1, that would be fine. But student number 2 couldn't make that justification for wanting to go to school, or the school taking that into account would somehow be acting unconstitutionally. If this is kind of making your head spin, you and I are in similar company, and I'm quite concerned about the implications of this outside the scope even of affirmative action. But given that the headlines these days have been exclusively, the court is going to potentially reverse affirmative action without really explaining it, I thought it wasn't worth a few minutes to share with you a little more unpacking of what really is going on here. So thanks for listening. I'm Kim Whaley, and this is Simple Politics.